So we've left off talking about contracting systems, and we said the contracting system we're going to focus on for the first half of the class anyway is Article 2 of the Uniform Commercial Code. Now, Article 2 is a part of the Uniform Commercial Code. Now, once upon a time, every state had its own sales law, such that a sale was defined in different ways in different states. Guidance for the performance of the sales contract differed depending upon which state you were in. Remedies available for the failure to perform differed depending on which state you were in. And this was the system that was prevalent in the United States up through the 1930s, 1940s. Every state had its own sales law. And it was not that problematic because most sales were local back then. There was very little sales conducted across state borders. That would wait until the 1940s and the 1950s. And so it quickly became clear that a uniform set of rules governing sales contracts would promote commerce. By standardizing sales law, they're going to promote clarity as to what the law is, and even more important, they're going to promote predictability so that we know what are the requirements for a valid contract, how do we perform a contract, and what are the remedies if a contract is breached. Now, the Uniform Commercial Code is not a law in itself. The Uniform Commercial Code was prepared by scholars and by people working in the trade to provide a model statute for states to adopt. And so every state has adopted a form of the Uniform Commercial Code. I mentioned Louisiana last time. Louisiana has not adopted Article 2, but they have adopted other features of the Uniform Commercial Code. And the Uniform Commercial Code is not a law, but the states in their versions have made it the law. Now, the different versions of the UCC are remarkably similar, although the numbers may be changed or there may be some slight wording changes. For the most part, sales law is the same in 49 of the 50 states. So Article 2 of the UCC governs sale of goods nationwide. Now, in this lecture, what we're going to do is examine the UCC and the formation of contracts for the sale of goods. At the end of the lecture, you should be able to answer the following questions, which is to say, first of all, what is the UCC? What is a sales contract? And what kinds of contracts fall under the UCC? What types of contracts are subject to the UCC? And then, what is a merchant? And why is that designation significant? Because as we'll see, there can be different rules that apply to merchants as opposed to consumers. Now, the Uniform Commercial Code, although we're going to be talking about it mainly in the context of sales, at least for the first half of the class, the Uniform Commercial Code was designed to cover all of the phases of a commercial transaction. And this UCC is a model code adopted by almost every state. And as I mentioned, in the early years of the nation, sales law differed by state. Multi-state contracts made interstate commerce difficult, and therefore we developed a uniform code to govern commercial transactions throughout the United States. Now, the UCC's coverage is comprehensive. So Article 1 provides the definitions and the framework for the UCC. Article 2, what we'll be focusing on in the first half of the course, involves the sale of goods and probably the type of contract that you're most likely to encounter. Article 3 is what we will cover in the third part of the course, negotiable instruments. Those have to do with promissory notes and with items like checks. Article 4 governs bank deposits and collection. Article 7 governs documents of title. And finally, Article 9, which is what we'll finish out the semester with, governs secured transactions. And we'll talk more about negotiable instruments and secured transactions when we get there. Now, multiple aspects of the UCC may govern a single transaction, but we know that Article 2 of the UCC governs contracts for the sale of goods. And the first thing we have to look at is sale. What is the definition of a sale? Well, according to the UCC, a sale is the passing of title from the seller to the buyer for a price. Now, we'll be doing a lot of this in this course, which is to break down this definition and to look for elements that reflect the definition. So in this definition, the passing of title from the seller to the buyer for a price, we know that a sale of goods occurs when a seller transfers to a buyer title to goods in exchange for a price. So if these things are not occurring, if there is not a transfer of goods, title to goods from a seller to a buyer in exchange for a price, then no sale of goods has occurred, and therefore the Article 2 of the UCC will not apply. Now, when we talk about price, the price can be payable in money, in goods, or in services. So we could have a sale of goods in which the goods are going to be paid for through a promissory note, which is going to be governed by Article 3 of the UCC. What is a good? Well, a good is a tangible thing that is movable. And tangible property is personal property that has inherent physical value. There is a value to this item. It can be moved from place to place. If it's attached to real property, it can be severed from the real property without doing harm to either the land or the severed personal property. So a good is personal property. If you recall from your 3213, property falls into two categories: real property, which is land or anything attached to the land, and personal property, which is anything that is not attached to the land or can be severed without difficulty. So goods has a very broad meaning. Goods also includes crops and timber. A good can be animals, and in fact it can be the unborn young of animals. A good can be minerals that are going to be removed from the real property and severed by the seller. So if I sell you the minerals beneath my land and I remove those and give them to you, then that's a good, even though I'm removing it from the land. A good could also be a structure or materials to be removed from real property that are going to be severed by the seller. So a house is ordinarily going to be considered real property. However, if I'm going to sell you the lumber from the house, and you're going to take it with you and move it away, that then becomes a sale of goods. Now, the term goods does not include intangible things such as intellectual property, patents, copyrights, trademarks. Those are not goods. Sale of those are going to be governed by the common law. Investment securities, things like stocks and bonds, minerals that are going to be removed from the real property by the buyer, or a structure or materials that are going to be removed from the property by the buyer. So the term goods does not include those items. Sometimes a good can change its nature. So if I sell you a towel rack, for instance, when you buy that at Lowe's, you are buying a good. But then when you go to your house and you attach it in a way that it could not be removed easily, it has become real property. Sometimes questions arise whether Article 2 applies to the contract or not. And this tends to occur when goods and services are mixed up in the same contract. There are a large number of disputes involving goods that also involve services, real property, or intangible personal property. And therefore, courts must decide whether to apply Article 2 by using one of two tests. Now, a transaction can only be governed by one contracting system. It can be governed by the common law or it can be governed by the UCC, but it cannot be governed by both. Know that for the purposes of your test, if there's a question involving which contracting system applies, and one of the answers is both the UCC and the common law, you know that's the wrong answer. So courts decide whether to apply Article 2 to a mixed goods and services contract by using one of two tests. And the tests are going to differ depending on which state you are in. Because the UCC does not provide definitive guidance as to which contracting system applies to a dispute involving mixed goods and services. There's these two tests, and the first test is known as the predominant purpose test. And the predominant purpose test looks to see what was the main purpose of the underlying transaction. This is the majority of the states use a form of this test. Approximately 2/3 of the states use the predominant purpose test. And what the predominant purpose test does is to look at what is occurring, what is the point of the transaction. So if I hire you to install a swimming pool, and that installation requires bringing in heavy equipment, digging a big hole in my yard, and then putting in a fiberglass shell, well, obviously goods and services are going to be mixed. The shell is going to be a good. The work that you do to put in the pool is a service. What was the main purpose of the underlying transaction? Well, in this example, the main purpose is installation of the pool. That's what the dispute was about. That's what the contract was about. So in any dispute arising out of this contract, the common law will apply because the purpose of the transaction was a service, the installation of the pool. We can often decide what's the main purpose by looking at the allocation of cost. If a contract costs a certain amount, what you'll want to do in order to determine the predominant purpose is to look at the cost of the service versus the cost of the good. So if Oklahoma State University decided to replace all of its chalkboards with electronic whiteboards, and they hired a company to install those, and $40,000 of the $50,000 contract was for removal of the chalkboards and installation of the whiteboards, and $10,000 of the $50,000 contract was for the whiteboards, then the predominant purpose was the installation of the whiteboards. Therefore, this contract would be governed by the common law. Now, the other test, the minority test, is known as the gravamen test. And in this test, what we look to see is what part of the underlying transaction gave rise to the dispute. What was the dispute about? Was the dispute about the installation, or was it about the good itself? So, say in that same swimming pool example as I gave above, swimming pool, installation of the swimming pool is clearly the main purpose of the underlying transaction. But say we had a dispute that was caused by the failure of a diving board that came with the transaction. They put in a diving board as part of the swimming pool. Someone jumps on the diving board, it breaks and causes an injury. In order to determine which contracting system will apply in that case, we look to see what is the dispute about. And even though the purpose of the contract was the installation of the pool, the focus of the dispute was about the defective diving board. So in those states, and again, this is about a third of the states, we look to see not what's the predominant purpose of the transaction, but to see what part of the underlying transaction is at dispute. Is it the service or is it the good? In the swimming pool example, if the problem was caused by faulty installation, then it's going to be governed by the common law. If it's caused by a faulty good, it's going to be covered by the UCC. So make sure you know these two tests, know the difference between the two, and be able to recognize that on your test problems. What is a merchant? Now, the UCC applies sometimes special standards to merchants. So, what is a merchant? Who is a merchant? A merchant is a person who deals in goods of the kind involved in the contract. So, a company that sells bookcases is a merchant for bookcases. An entity that deals in goods of the kind involved in the contract. So if I am buying bookcases for my library, then I can buy those from a bookcase seller, which would be considered a merchant. A merchant is also a person who, by their occupation, holds themselves out as having knowledge or skill peculiar to the practices or goods involved in the transaction. Or a merchant could also be a broker or agent or an employee of a merchant. Now, a merchant for one type of goods is not necessarily a merchant for a party could sell a good, and the party may be a merchant for one type of good, but it may not be a merchant for the type of goods involved in the transaction. So, say a company that sells toys is a merchant for the sale of toys. But if that toy company decides to remodel its store, and therefore that means selling all of the shelving in the store and replacing it with new shelving, when the seller sells that shelving, it is not a merchant for shelving. So it would not be treated as a merchant by the UCC. The parties to a contract under the UCC must perform in good faith. Every contract governed by the UCC imposes an obligation of good faith in its performance. Now, this is different from the common law. When you enter into a contract in the common law, there is not necessarily a requirement that you act in good faith. But the UCC imposes this requirement, and it is an obligation under every contract under the UCC. Now, the UCC defines good faith as honesty in fact in the conduct or transaction concerned, meaning the party must be honest in the transaction. Merchants, however, are subject to an additional good faith standard. Merchants are required to act honestly, but they must also observe reasonable commercial standards of fair dealing in the trade. So the duty of good faith, and again we'll talk about this when we get to warranties, but the duty of good faith cannot be waived. It cannot be disclaimed. It is present in every contract, even if the parties agree that there is no duty of good faith. The duty of good faith imposed by the UCC supersedes that agreement. It's one of the few cases where the parties cannot agree on a matter and take it outside of the UCC. Finally, we'll talk about Article 2A a bit. Article 2A governs contracts for the lease of goods, and a lease of goods is covered in this article that any transaction that involves the lease of goods. Now, when we lease a good, Article 2A defines a lease as the bargain between a lessor and a lessee. And a lease is a transfer of the right to possess and use goods for a period of time in exchange for payment. Thus, in a lease, there are three elements. There must be a good. The good must, a party must sell the right to use and possess the good for a term, a period of time, and there must be consideration paid for that. Now, a lessor is one who sells the right to possession and use of the goods under a lease. A lessor may have title to the goods, but the lessor is going to transfer the right to use the good to the lessee. Lessee is the person who acquires the right to possession and the use of goods under a lease. We won't be talking a lot about leases in here, but Article 2A is very similar to Article 2. A lessor will have the same obligations, for the most part, as a seller. And a lessee will have the same duties and obligations and rights as a buyer. So whenever you see buyer and seller referenced in one of the rules regarding the sale of goods, understand that in a lease of those goods, the lessor takes the place of the buyer, of the seller, and the lessee takes the place of the buyer. So in conclusion, what did we learn today? The UCC governs all the phases of an ordinary sale or lease of goods. Article 2 of the UCC governs contracts for the sale of goods, and Article 2A governs contracts for the lease of goods. And that's it. Thanks for listening.